Hey everybody, welcome back to the second video for the intro to the Constitution for American Government that you will be working on this week. We left off on Article 4 in the last video, so we're going to start off at Article 5, which lays out the ways the Constitution can be amended or changed. So it talks about in Article 5 how to change the Constitution or to amend it, which includes 2/3 of both houses deeming it necessary. They'll propose an amendment to the Constitution, and then they would vote on that, okay? There's a whole lot of other things in play here, but for the most part, to amend the Constitution is very difficult, and it does take a lot of time and purpose. 3/4 of the states needs to agree on the changing of the Constitution, or a convention would need to do that. Okay, so there's a lot of different things that have to be not only proposed but completed and voted on before any changes can be done. It's very difficult. Moving on to Article number 6 explains the Supremacy Clause, which is the supreme law of the land, which would be the Constitution, laws passed by Congress, and treaties of the United States shall be deemed higher than any other laws in the United States. So, for instance, any laws that are passed within a state are valid within those states as long as they're not unconstitutional. But if they were to supersede or to appear that they were above any federal laws that are in place, that would not be okay. Federal law, Constitution, all of those things will take immediate authority over any state law, local law, anything of that nature, okay? So we call it the supreme law of the land. The Constitution is the supreme law of the land. So just keep that in mind whenever anybody talks about the tiers of the laws that are in place. The Supremacy Clause will state that the Constitution and federal laws take priority over any other laws that are conflicting. So this might be something of interest, including the discussion on the legalization of marijuana. So several states have legalized marijuana as a recreational drug that is allowed to be done within, parameters of whatever have been deemed okay. But federally, marijuana is still an illegal drug. So federal precedents on this would take over and rule that. So just keep that in mind. Just because a state makes a law saying that something is legal, it might be legal within that state, but the federal law still takes precedence and authority over that. So technically, the president could enforce it by sending the DEA in and shutting down any of those things, but that takes a lot of time and money and effort. So you just have to understand that just because something is said to be legal in a state doesn't necessarily mean that it is federally legal. Article 7 addresses ratification and declares that the Constitution would take effect after it was ratified by 9 states. So this was just basically saying that how the states would sign or give formal consent, making the Constitution valid. And it goes about that the 9 states had to ratify it or had to give approval for the Constitution to take place. Okay. So let's get into the amendments. Like I said earlier, the amendments are very difficult. It's very difficult to amend the Constitution. It's only happened 27 times since the Constitution was ratified. And this just provides a way that things can be changed if necessary based on the changing tides of society. This doesn't usually happen overnight. It takes sometimes generations to get things passed. But again, it's only been amended or changed 27 times, and that is including the first 10 amendments, which happened immediately after the ratification of the Constitution. Major principles in the Constitution are popular sovereignty, federalism, separation of powers, checks and balances, judicial review, and limited government. So we're going to go over these major principles, and then we'll be finished with this slide. Or this PowerPoint, okay? But the first thing we want to talk about is popular sovereignty. It's this concept of rule by the people. So the government gets its consent to govern the people from the people. So that's where our ideas of voting and democracy come into play. So popular sovereignty just means rule by the people. Federalism. Now, federalism is a tricky term and idea that a lot of students have difficulty with, and we will focus a lot on it. But federalism ultimately is the power divided between the national and state governments, meaning that both the national and state governments can create laws, right? They can enforce those laws. And sometimes they share powers to make laws. So if you think about it, gun control, marijuana, drugs, things of that nature. Both entities, the federal government and states, have made laws according to the constituents of their location or their area, and have made those laws for their purposes. Okay, so but again, a state cannot make a law that supersedes the federal government's laws, and at the same time, though, it's a middle ground compromise to the states, because the states never intended to have the central government be more powerful than them. But in order to have a solid system, we had to have a government where the central government was the founding power and could raise money for whatever it needed in order to run the country. So just realize that federalism is the power that's divided between national and state governments. Both sets can make and enforce laws. They may differ a little bit or even contradict each other, but the federal law will always supersede any state laws. Separation of powers. The Constitution limits the central government by dividing power among the legislative, executive, and judicial branches. It just basically means that each branch has its own responsibilities. The legislative branch makes laws, the executive branch enforces laws, and the judicial branch determines whether or not these laws or activities that are done or actions are constitutional. Checks and balances. The principle of checks and balances is that each branch can exercise some control over the other branches. So for instance, when Congress passes a law, the president can check Congress by vetoing the law, which is rejecting it. So veto means rejection. Now, if the president vetoes it and Congress decides and they get 2/3 the vote and they override him, they can also check his power as well. Okay. The judicial branch can override Congress when they state basically it's an unconstitutional if the law is found to be unconstitutional. So there's many checks and balances within the system that are built in, and it is designed that way so one branch doesn't have the entire power over the other two systems. Judicial review. Judicial review will come up quite a bit in the units ahead. And when we talk about it, it's the power that the courts have to declare laws and actions of local, state, and national government invalid or constitutional if they violate the Constitution. So all federal courts have this power. They can do that. But the Supreme Court has the final authority. So whatever they say goes, and the Supreme Court cannot be overturned by any other court decision unless the Supreme Court itself reverses its decision or makes its changes. Okay. Now, judicial review didn't really come into play until about 1803 in the case of Marbury v. Madison. In this case, Justice John Marshall made a decision that basically was a power grab for the judicial branch, and that they would get the final say over cases involving the Constitution and laws. So we'll get more into Marbury v. Madison. That is a court case that we will discuss, and just understand that in the scheme of things, judicial review was never really something that was there, but it did end up evolving into that as we got underway as a nation. Limited government. This is the last slide. And ultimately, the founders wanted there to be a limited amount of government. The Constitution limits the actions of the government by specifically listing powers it does and does not have. Okay, the first 10 amendments specify limits in the areas of freedom of expression, personal security, and fair trials. Now, in order for the Constitution to be ratified, the Bill of Rights had to be written to compromise with the states who were not very comfortable with the original version of the Constitution. So the amendments had to be supplied and promised in order to get those states to ratify it. And those amendments were originally designed to protect states from the federal or central government. And now we use those amendments more as a personal civil liberties thing as well. So it's kind of evolved into that as well. If you have any questions, again, email, call, text, I'm here to help. If you have any questions that would benefit the class, please put them in the discussion board. Otherwise, make sure that you have filled out your PowerPoint slides with the necessary notes that you would need. You do have a quiz based on these terms. And also make sure that each slide has a picture that you have chosen that will help you remember those terms and meanings, okay? I hope you have a great day, and I will talk to you soon.